So can you lie in a negotiation? Is that fair game? Is anything goes in a lawyer negotiation? Obviously, when you talk about that question, you're talking about really two things. One is you're talking about the rules of professional responsibility and whether or not there's a risk from the rules of professional responsibility. You're also talking about personal integrity, and I want to talk about both of those things and how they relate to negotiation styles and strategies. First of all, let's be clear that the model rules of professional responsibility do not provide a real easy answer to the question of whether or not, in fact, something is a misrepresentation or a lie. That is, that they are very clear that you're not supposed to lie, but let's walk through what's going on in the relationship which complicates the answer to the question of lying and misrepresentation. First, it is important to realize that you can't go off as a negotiator on your own and decide for yourself how this problem ought to be solved. The problem, the objectives of a client's dispute are the client's. And so they control them, and there are confidentiality obligations then that are also in play. And you shall abide by the client's decisions with regard to the objectives of the litigation. However, in that process, are you freed up to lie on behalf of the client to get the client what the client wants? Well, 3.4 provides that you're not supposed to, with opposing party and counsel, falsify evidence, or counsel or assist a witness testifying falsely. So no misrepresentations are going to be part of what it is that you are going to say to the other side. You can't lie when you know something is false. And in 4.1 of the model rules, it's clear that there are obligations of truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a person, or, and here's an interesting move, fail to disclose a material fact to a person when disclosure is necessary to avoid assisting in a criminal or fraudulent act by a client unless disclosure is prohibited by 1.6. Now let's go back to each one of these and let's think about them for a second. What is a material misrepresentation? What's a material misrepresentation? Remember the Bill Clinton argument about the deposition that he took in the Paula Jones case. Questions about Monica Lewinsky, he could say, hey, I can lie about those. The reason is, what does Paula Jones have to do with Monica Lewinsky? Monica Lewinsky has happened some numbers of years after Paula Jones. What in the world is the relationship between those two? They're not material to the lawsuit. Of course, materiality is in the eye of the beholder. The fact that he has a character flaw which makes him hit on staff people may be evidence of whether he did so in the Paula Jones case. But you can see how you might talk yourself into, well, it's okay to lie because it's just not a material misrepresentation. When you're talking about that in the heat of the moment, be careful that you get some perspective and objectivity. That what you're doing is you're asking yourself whether or not the materiality of that is as a matter of law. Do you need to get a ruling about that? Might you get a ruling about that in this case to free yourself up to be able to do it? Or whether or not, in fact, it's going to be material then because it shows weakness on your part. Whether statements should be considered one of fact can depend on the circumstances. And of course, fact statements are different from opinions or different from the kinds of things that we say that are really not meant to generate reliance. And we talk about facts under generally accepted conventions and negotiations. Certain types of statements ordinarily are not taken as statements of material fact. Look at these in particular. There are two here to point out. Estimates of price or value on the subject of a transaction and a party's intentions as to an acceptable settlement or claim are in this category. Those two estimates of price and value, I think, make perfect sense. First of all, if I say to you, what is your car worth? And you say, well, the price for the car is $18,000, even though you think that the true value of it is much less than that. Your statement about $18,000 is not a factual statement. It is an estimate of price or value that you're putting on the particular commodity, and there is no factual basis for it. Distinguish, though, between a statement like that and I've had it appraised at $18,000 when no such appraisal exists. Estimates of price or value that are related to factual statements about documentation are a different sort and need to be looked at for the truthfulness of the statement. But this second one is probably more important. It relates to, in a negotiation, to the exchange that often occurs when you're trying to figure out whether the other side can move at all in the negotiation. So I ask, is that your bottom line? Can you move? Is that all you've got to give on this? Note here, comment 2 says that parties' intentions as to acceptable settlements are in a category of not being factual. Well, does that mean I'm freed up to lie? Well, let's go back to the question of then what the rules provide. It does look like the rules provide some room here to say, no, there's no room to lie, because they're not supposed to be heard as statements of fact. On the other hand, in terms of personal integrity, to say no, when in fact you do have authority to move, risks your own integrity in the negotiation going forward. As a quick answer to a much longer discussion that needs to be had on this point, let me suggest to you that there are some things that you can say in these situations that may help you keep the conversation going without risking some integrity. One is to say, rule the question out of bounds. You know, that's an unfair question, and frankly, it's way too early for us to be talking about those kinds of questions. We've got a lot more to understand about each other before we go forward. Number 2, to say, are we talking about trading bottom lines here? Is that what we're doing? Well, how are we going to judge the veracity of the bottom lines we trade? Or number 3, to say, Jim, you know, I won't answer that question. I think that that's not appropriate. Or I'm sorry, the one that I wanted to talk to is, well, you know, there's always the potential that my client may change his position, but I haven't heard anything so far that would allow me to recommend that my client changes his position on that bottom line. That those kinds of then solutions, I hope, protect your integrity, but show some kind of openness still to talk some more. And the reason for that is that if you didn't have any more authority, the answer would be short and sweet, wouldn't it? It would just be, no, I can't move. And so really any other answer besides no gives the person on the other side the answer they're looking for. It's why the question is unfair. But think about your integrity in the process, and I encourage you to use some of these caveats. Well, we're always open to move if there's some reason to move. Or I could go back to my client with a different offer if I had reason to. Frankly, at this point, I'm not willing to do that. Those kinds of answers may protect your integrity, even though under the rules and the comments, there may be freedom for you to just simply say no.